Hi everyone, I Dr. Varun Kumar from Tecnia Institute of Advanced Studies. Now I am presenting a lecture on business law. Firstly, we will discuss the concept of business law. Business can be classified in two categories, busy plus ness. Busy in exchange of goods and services. Ness is similar to continuous. So, business is a continuous process of exchange of goods and services. On the other hand, law is a rule that can be enforced by the court. So, business law is related to all the rules which implement on business. Now, we have a question, what is contract? According to the Indian Contract Act, the term contract is defined in section 2H of the Indian Contract Act, which reads as under an agreement enforceable by law is a contract. The analysis of this definition shows that contract must have the following two elements. The first one is agreement and second one is the agreement must be enforceable by law. In other words, we can say that contract equal to agreement plus law. According to section 2E, agreement, every promise and every set of promises forming the consideration for each other is an agreement. According to section 2B, we can define the concept of promise. A proposal when accepted becomes a promise. Every agreement is not a contract. When an agreement creates some legal obligations and is enforceable by law, it is regarded as a contract. Now we will discuss essential elements of a contract. We will discuss one by one. First, two parties. Second, offer and acceptance. Third, free consent. Fourth, lawful consideration. Fifth, lawful object. Sixth, capacity to parties. 7. Possibility of performance. 8. Last but not the least, written and registered. Now we will discuss one by one in briefly. Firstly, two parties. Every contract has minimum two parties. One party is a seller, second is a buyer. In simple word, we can say one is the offerer, second one is acceptor. Second point is offer and acceptance. Firstly, what is offer? Offer is a proposal when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of other to such act. He is said to make a proposal. This definition under section 2A. Now, we'll have to discuss what are the essential requirements of a valid offer. First, the offer must be communicated to the offeree. Second, the offer must be made with a view to obtain acceptance. Third, the offer must be made with the intention of creating legal relation. Third, the term of offer must be defined, unambiguous and certain. Fourth, an offer must be distinguished from invitation to an offer. Here I want to discuss with you, offer is not an invitation to an offer. Like for example, a prospectus issued by a company for subscription of its share by the member of the public is an invitation to the offer. The letter of offer issued by a company to its existing shareholder is an offer. After discuss the concept of essential features of offer, we'll have to discuss a concept cross offer, where two parties make identical offer to each other in ignorance of each other's offer. The offers are known as cross offer, and neither of the two can be called an acceptance of the other hand. Therefore, there is no contract. So, in simple word, we can say cross offer doesn't create a valid contract. Now we will discuss termination or lapse of an offer. How offer can be lapse or termination? Firstly, the offer lapses after reasonable time. Second point, an offer lapses by the death or insanity of the offerer or offeree. Third point is an offer terminates when rejected by the offeree. Number 4, an offer terminates by not being accepted in the mode prescribed. And last, a conditional offer terminates when the condition is not accepted by the offeree. After we discuss the offer, we will discuss acceptance. Acceptance has been defined as when the person to whom the proposal is made signifies his assent thereto. The proposal is said to be accepted. Now, what are the essentials of a valid acceptance? Major 3 points we will discuss essentials of a valid acceptance. First, acceptance must be absolute and unqualified. Second one, acceptance must be communicated to the offerer. And third one is acceptance must be according to the mode prescribed. After the discuss of offer and acceptance, we have a third essential element of a valid contract is free consent. When two or more persons agree upon the same things in the same sense, they are said to be consent. For example, A agreed to sell his Fiat car model for rupees 80,000. B agreed to buy the same. There is a valid contract because A and B have consented to the same subject matter. Now, consent is said to be free when it is not caused by the following reasons. First, under coercion. Second one is undue influence. Third one is fraud. Fourth one is misrepresentation. And fifth is by mistake. Our first point is coercion. Under section 15, it is committing or threatening to commit any act forbidden by Indian Penal Code. For example, A threatens B at a gunpoint to sell his car to A. This example related to not free consent. Second point is undue influence under section 16. Undue influence, a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties in a position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. Third point is fraud. Fraud means which include intent to deceive another party. Now we have a question. Is silence a fraud? So according to section 17 states in clear term that mere silence is not a fraud. Where silence amount to active consentment, it shall amount to fraud. This concept we will discuss by a wonderful example. First, a sales by auction to B a horse which A knows to be unsound. A says nothing to B about the horse's unsoundness. This is not a fraud by A. On the other hand, if B says to A, if you do not deny it, I shall assume that the horse is sound. Here, A's silence is equivalent to speech. Here, the relation between the parties would make it A's duty to tell B if the horse is unsound. Next point is misrepresentation. Misrepresentation is any breach of duty which without an intent to deceive. Under misrepresentation, we can say that it is unintentionally deceive. Now, we can classify the difference between fraud and misrepresentation. We can take only three important points which classify the difference between fraud and misrepresentation. First, intention. As earlier we have discussed, a fraud, the party's intention is to deceive the other party. On the other hand, misrepresentation, the party does not have any intention to deceive. Second point is rights. Fraud gives two rights to the aggrieved party, a right to action for damage and also to avoid the contract, while misrepresentation gives only one right to avoid a contract. It does not allow any damages. Third point is penalty. The party defrauding the other can be prosecuted for cheating under IPC also, but such is not the case in misrepresentation. Last one, make mistake. Mistakes by facts. Mistake by facts can be classified in two categories. The first one is bilateral and second one is unilateral. First, bilateral means mistake of both the parties. On the other hand, contract caused by mistake of one party as to matter of fact unilateral. The fourth essential element of a valid contract is consideration. Consideration is what a promisor demands as the price for the promise. In simple word, it means something in return. Kind of consideration we can classify again two categories. The first one is executed and second one is executory. The fifth element of an essential valid contract is legality of object. An agreement will not be enforceable if its object or the consideration is unlawful. According to section 23 of the Act, the consideration and the object of an agreement are unlawful in the following cases. A. If it is forbidden by law. B. If it is fraudulent activities. C. If the court regards it as immoral. And last, if it involves injury to the person or the property of another person. The sixth element of an essential element of valid contract is capacity to parties. Yes, parties must be capable to enter a valid contract. Now question arises, who are not capable, who are not competent to enter in valid contract? So, we have three categories which are not competent to contract. The first one is minor. Who is a minor? As per Indian Majority Act 1875 states that every person domiciled in India shall attain the age of majority on completion of 18 years and not before. A contract with or by a minor is void. A minor therefore cannot bind himself by a contract. A minor has received any benefit under a void contract, he cannot be asked to refund the same. So, our second point is mental incompetence. In mental incompetence, we can say that a person is an unsound mind. Like a person is said to be unsound mind for the purpose of making a contract if at the time when he makes it, he is incapable of understanding it. What is the contract? What is the agreement? So, forming a rational judgment as to its object upon his interest. A person is said to be unsound mind for the purpose of making a contract if at the time when he makes it, he is incapable of understanding it and of forming a rational judgment as to its effect upon his interest. A person who is usually of unsound mind but occasionally of sound mind may make a contract when he is of sound mind. First category under incompetencies through status. First one is alien enemy. Second one is foreign sovereigner and ambassador. Number 3, any company under the Company Act or statutory corporation by passing special act of parliament. And last but not the least, insolvent person. Yes, insolvent person cannot enter a valid contract because he is incompetent to enter a valid contract. Seventh essential element is possibility of performance. Yes, performance must be possible for a valid contract. In simple word, we can say that if performance is not possible, a valid contract cannot be occurred. So, the agreement between parties must be certain. It should not be vague, indefinite, or if it is vague, it is not a contract or cannot be enforced. For example, A agree with B to put life into B's dead child. The agreement is totally void as it is impossible of performance. This example relate to section 56. The 8th point, which is the last point, the contract must be written and registered because of evidence. Written and registered contract can be shown as evidence in the court or in a legal authority. So, now we will discuss the classification of contract. Firstly, we can classify the contract in 3 categories. First, classification based on enforceability. Second one is classification based on mode of formation. Third, classification according to performance. Now, we will discuss one by one. According to the enforceability, we can classify the contract in 4 categories: valid, voidable, void, and last, illegal. According to the formation, we can classify the contract in 2 categories: express contract, implied contract. Last, according to the performance, we can classify the contract in 2 categories. The first one is executed contract and second one is executory contract. Now, we will discuss one by one. Firstly, based on enforceability. The first type of contract under the enforceability. The first one is valid contract. Now, what is valid contract? A contract which duly follow the laws prescribed by any court of law is said to be a valid contract. In simple word, we can say, earlier we have discussed the essential element of a valid contract. Which contract have all essential elements? Last, all above 8 essential elements, we can say that it's a valid contract. For example, a man offers to marry a woman. The woman agrees to his offer. Second type is void contract. At the time of contracting, the contract was valid, but in due course of time, the contract becomes void due to several reasons like a change of law or a subsequent amendment to it. Performance degradation and other unforeseeable circumstances. For example, a man marries a woman with her consent, but later on, woman dies due to illness. So initially, the contract was valid and the same become void due to the death of a spouse. Void contract is related to void agreement. If an agreement isn't enforceable by law, then such type of an agreement is said to be void. For example, an agreement made with a minor or a person of unsound mind or a drunken person is considered to be void. The major difference between void agreement and void contract is void agreement at the time of making it is void, it is not valid. But in void contract, at the time of making it is valid, but after some due circumstances it become void. The third one is voidable contract, an agreement which is enforceable by one or more of the legally bound parties but not at the option of the other parties. At the time of contracting, the contract was not valid due to not consent of one parties. And fourth one is illegal agreement. Illegal agreement are void from the very beginning because the agreement made cannot be enforced by any law. For example, a contract killing or supari killing is void from the very beginning. Second one is, now we will discuss based on creation. We can classify the contract based on creation in two types. As earlier I told you, express contract and implied contract. Now, what is express contract? An express contract deals with a contract which is either made by spoken words or a written document. Example, a customer buying a flat from a broker with a written document. Each and every rules and regulation, term and conditions are classified, are explained in express contract. On the other hand, implied contract, a contract which doesn't explain all the rules and regulations. An implied contract deals with a contract which is made in any way other than a verbal agreement or a written record. For example, a bus shuttle service from the state government applies in a city. To use its services, you have to buy a ticket, or the shuttle services isn't exclusively operating for you. Now, we can discuss the type of an implied contract. So, one major type of implied contract is a quasi contract. In case of quasi contract, there will be no offer, no acceptance. So, actually there will be no contractual relation between the parties or partners. Such a contract which is created by virtue of law is called contract. Now we will discuss section 68 to 72 of Contract Act which explain the situation where court can create a quasi contract. First, according to section 68, when necessaries are supplied. Section 69, when expenses of one person are paid by another person. Section 70, when one party is benefited by the activity of another party. Section 71, in case of finder of lost tools. Section 72, when payment is made by mistake or goods are delivered by a mistake. For example, a case on the occasion is Chowels versus Coopers. In this case, A's husband become no more. She is very poor and therefore not capable of meeting even cost of crimination. B, one of her relatives understand her position and spend his own money for crimination. It is done so without A's request. Afterward, B claim his amount from A where A refuses to pay. Here court applies section 68 and create a quasi contract between them. Now we will discuss the three category of types of contract which based on execution. Based on execution, we can classify two types of contract. The first one is executed and second one is executory. Executed contract, this is a contract signed between two parties who have performed their legal obligations under the contract. In simple word, we can say executed contract where both parties have done their performance or obligations at the time of making contract. For example, a person selling his car to another person saying the car is for sale for a sum of rupees 5 lakh rupees and the same being obligated. Second one is executory contract. This is a contract signed between two parties who are yet to perform their legal obligations under the contract. In simple word, we can say that executory contract where both parties or any one parties haven't performed their obligations. For example, a person offer his bike for 1 lakh rupees and another person accept the offers. But the bike is yet to be delivered and the amount for it is also yet to be paid. So, executory contract, we can say that executory contract is a type of future contract because under this contract, the obligations or performance will be occur in future.